Part 1 is Union and its territory. Article 1 is the name and territory of the Union. Clause 1, if there shall Bharat, that is in India, that is Bharat, shall be Union of States. Clause 2, the states and the Union territories shall be as specified in the first schedule. Clause 3, the states and the territories of the state of India shall comprise of the territories of the state. B is the territories of the Union territories as may be specified in the first schedule and other territories as may be required. Then Article 2 is admission or establishment of new states. Then Parliament may by law admit into Union and or establish new states on such terms and conditions as it may think fit. Then Article 2A was repealed by the 36th Amendment Act 1975. Then Article 3 is formation of new states and alteration of areas, boundaries and the names of the existing states. Parliament may by law can form the new states by the separation of territory from any part of the state, or by uniting two or more states or the part of states, or by uniting the Union territory to any part of the state, or increase the area of the state, or diminish the area of the state, or alter the boundaries of the state, or alter the name of the state or of any state. But no bill shall be introduced in either house of the Parliament except on the recommendation of the President, or unless when such provision contained in this bill affects the areas, boundary, or any name of the existing states, and this bill has been referred by the President to the legislature of state within such period as may be specified, for expressing its views within such period as may be specified by the President, or within further period as the President may allow. And then explanation 1 is in this article from clause A to E. The state shall include the Union territories, but in the proviso, the state does not include the Union territories. Then explanation 2 is the power conferred by the Parliament shall include the power to form any part of the states or Union territories by uniting any part of the state or Union territory to other state or territory. Then Article 4 is laws made under Article 2 and 3, which are to provide for the amendment for the post and fourth schedule and incidental, supplemental and consequential methods. So in clause 1 it's given that laws referred to in clause 1 and 2 shall clause 2 and 3 laws referred to in article 2 and 3 shall contain such provision for the amendment of the fourth schedule and fourth schedule, and shall as may be as to give effect to the provision of the law, and shall also contain the incidental, supplemental and consequential methods, also including the reference in the Parliament, the presentation in the Parliament of the legislature of states as the Parliament may deem necessary. Then clause 2 says that nothing in this article shall be deemed to be an amendment of the Constitution for the purpose of Article 368. Then part 2 is citizenship. Article 5, citizenship at the commencement of the Constitution. In this article, it's given that at the commencement of this Constitution, any person who is born, or his parents or his grandparents were born in India, or is an ordinary resident for not less than 5 years, shall be deemed to be citizen of India. Then Article 6 is right of citizenship of certain person who are migrated to India from Pakistan. So in this article, it's given that the person who is migrated to the territory of India from the territory as now included in Pakistan shall be deemed to be citizen of India if he has been the ordinary resident of India. In the case where he has been migrated before the 19th of July 1975, he has been ordinary resident of the India, and in the case where he has been migrated on or after the 19th of July 1975, he has been registered as a citizen of India on behalf by the officer of the government of Dominion of India. Then Article 7 is rights of citizenship for the migrants to Pakistan. The persons who are migrated from the territory of India to the territory of Pakistan after 1st of July 1947 shall not be deemed to be citizen of India. And then Article 8 is right of citizenship of certain persons of certain person of Indian origin, but who are residing outside the India. So in this article, it's given that any citizen, any person who is residing out, who is of India origin and residing in any country outside India, shall be deemed to be citizen of India if he has been registered as the citizen of India. Then Article 10, at Article 9 is the rights of the person who have voluntarily acquired citizenship of a foreign state not to be citizens. Then the person who is voluntarily acquired for the citizenship of a foreign state shall not be deemed to be citizen of India. And then Article 10 is continuance of the rights of citizenship. All the citizens who are deemed to be citizens of India shall continue to be such citizens. Article 11 is rights to Parliament to regulate the rights of citizenship by law. So nothing in the foregoing provision of this part shall derogate from the power of Parliament to make any provision relating to the acquisition and termination of citizenship or any articles related to or any provision relating to the citizenship. Then part 3 is fundamental rights. Article 12 is state. State must include the government and the Parliament of India and the government and the legislature of state or local or other authority within the territory of India or under the government of India. Then Article 14 is equality. Article 13 is laws which are inconsistent or in derogation with the fundamental rights. So clause 1 says, so all the laws enforced within the territory of India immediately before the commencement of the act, if they are inconsistent with the laws conferred by this part, they shall be, to the extent of such inconsistency, they shall be void. Then clause 2 says that the state shall not make any law which takes away or abridges the rights conferred by this part. If any contravention is made, then to the extent of such contravention, such laws shall be void. Then Article 3 says that in this article, the law includes ordinance, order, rules, regulation, notification, custom and uses of inhabiting the territory of India. And rule of law in force includes the laws passed and made by the legislature within the territory of India before the commencement of the Constitution, which are not previously repealed. Then Article 14 is equality before law. The state shall not deny the equality to any person, the equality of law before law and the protection of equal laws within the territory of India. Then Article 15 is prohibition of discrimination on the grounds of religion, race, sex, caste or place of birth. So in clause 1 it's given that the state shall not deny any citizen on the grounds of religion, race, caste, sex or place of birth or any of them. Then clause 2 says that any citizen shall, on the grounds of religion, race, sex, place of birth, or any of them, be subject to liability, disability, restriction, or condition with regard to the access to shops, public restaurants, hotels, and public places of entertainment. And second one is the use of wells, stands, bathing guards, and the roads, and the public places of resorts, maintained only by the state and which are dedicated to the use of the general public. Then clause 3 says that nothing in this article shall prevent the state from making any special provision for children and women. Subclause 4 is nothing in its article shall prevent the state from making any provision for the advancement of the socially and educationally backward people, and it shall also include the scheduled tribes and scheduled castes. Then clause 5 is nothing in this article shall restrict the state from making any provision for the advancement of socially backward and socially educationally backward of the citizens in relation to the admission into educational institution, including the private institution, whether they are aided or not unaided by the government of India. Then Article 6 is related to the same, it is like same as clause 5, but it is special. The state can make provision for the advancement of the economically weaker section other than the clause mentioned in clause 4 and 5. Then Article 16 is equality of opportunity in matters of public employment. Then clause 1 says that there shall be equality of opportunities in the matters of the employment and the appointments to office and in the service under the state. Then clause 2 says that the state shall not discriminate against, there shall be no discrimination on the grounds, no person, no citizen shall be ineligible, no citizen shall be on the grounds of religion, race, sex, caste, descent or residence or place of birth shall be ineligible or discriminated against in matters of the employment or the office under the state. Then Article 3 says that nothing in this article shall prevent the Parliament from making any law in the classes of employment and appointments under the government or the other local or other authority under the state in any requirement residence within that state or under the union territory of prior employment and appointment. Then Article 4 says that nothing in this article shall prevent the state from making any law for the reservation of the appointments and posts in the favor of the socially backward classes in which the state is in the opinion that they are not adequately represented in these services of the state. Then subclause 4A is nothing in this article shall prevent the state from making any reservation for appointment in matters of promotion of consequential seniority in the favor of scheduled tribes and scheduled castes. Then Article 4B, that nothing in this article shall prevent the state from considering any unfilled vacancy of that in the year in which they are being filled in accordance with the provision in which the reservation is made under clause 4A as a separate class of on which it is being filled and that such separate class shall not be considered together with the vacancies in the year in which they are being filled for the determination of 50% representation of the total vacancies in that post. Then Article 5, then subclause 5 is nothing in this article shall prevent the state from shall prevent the operation of the law provided that the incumbent of office shall, in relation to the affairs of the religious and denominational institutions or any person of the governing body, shall be the person of professing a particular religion or belonging to a particular denominational institution. Then Article 6 is that nothing in this article shall prevent the state from making any law for making any reservation for the appointment and post in the favor of educationally weaker section in addition to the existing states, and it's subject to 10% of the maximum posts in each category. Then Article 17 is abolition of untouchability. Untouchability is abolished and its practice in any form is forbidden, and untouchability shall be an offence which is punishable with the procedure by law. Then Article 18 is abolition of titles. First is no titles, not being a military and academic distinction, shall be conferred by the state. Second clause is no title that no person, no citizen of India shall accept any title from the foreign state. Then subclause 3 says that no person who is not a citizen of India but he holds office of profit or any trust under the state shall not accept the titles from any foreign state without the consent of the president. Then clause 4 is no person, while he holds office of profit or trust under the state, shall accept the present amusements or office from any other foreign state without the consent of the president. Then Article 19 is protection of certain rights regarding the expression of speech, etc. So clause 1 says that every person shall have the right of freedom and expression. B is to assemble peaceably and without arms, C is to form association or union territories or cooperative societies. D is to move freely for the territory of India. Then E is to reside in any part of the territory. E was repealed, which was right to property. Then F is to practice any profession and to carry on or trade, occupation or business. Then clause 2 says that nothing in clause A of subclause A of clause 1 of the said article shall affect the operation of the existing state and shall not restrict the state, shall not prevent the state from imposing reasonable restriction if they are in the interest of the sovereignty and integrity of India, or the security of the state, or the friendly relation with the state, or the decency, morality, public order, or in relation to contempt of court, defamation, or incitement of offences. Then subclause 3 says that nothing in clause B of the clause 1 shall affect the operation of law of the existing state and shall prevent the state from imposing reasonable restrictions if they are in the interest of the sovereignty and integrity of India or the public order. Then clause 4 says that if nothing in clause B or clause C of the said article shall affect the operation of law of the existing states or shall not prevent the state from imposing reasonable restrictions if they are in the interest of the sovereignty of India, sovereignty and integrity of India, or public order or morality. Then clause 4 and 5 says that if it is related to the clause B and E of the article 19 of the clause 1 of article 19, it shall not restrict any state from imposing reasonable restrictions if they are in the interest of the general public and for the protection of the interest of the scheduled tribes. Then 6th clause says that nothing in clause F, G of clause 1 of the article 19 shall affect the operation of existing state or prevent the state from the imposing reasonable restriction if it is the interest of the general interest of the public. Then article 20 is protection in respect of conviction for offences. So clause 1 says that no person shall be convicted for an offence except on the violation of law at the time of the commission of any offence or is subject to penalty greater than which might have been inflicted at the time of the commission of any offence. And second clause says that no person shall be prosecuted and punished for the same offence more than once. Then clause 3 says that no person shall be
22 बोलो कौन सा
the clause 3 of 20 no person shall be
prosecuted
and punished for the same offence. Shall be witnessed. Shall not be compelled. No person shall not be compelled to be witnessed against himself. Then article 21 is right, protection of life and personal liberty. No person shall be deprived of life and personal liberty except on the procedure established by law. Then article 22 is protection against arrest and detention, against arrest and detention in certain cases. So clause 1 says that no person who is arrested and detained in the custody, who is arrested shall not be detained in custody without being informed for such arrest and shall be given the right to consult and to be defended by the legal practitioner of his own choice. Then subclause 2 states that no person the person who is arrested and detained shall be produced before the nearest magistrate within the period of 24 hours, excluding the time of the journey from the place of arrest to the place of the court of magistrate, and such person shall not be arrested beyond the said period without the authority of the magistrate. And Article 3 says that nothing in subclause 1 and 2 of Article 22 shall apply to any person who is an enemy, alien, and who is a person who is detained or arrested under the law providing for the preventive retention. Then subclause 4 says that no law providing for the preventive retention shall authorize the detention of a person more than 3 months unless the advisory board consisting of a person who is qualified to be appointed as the judge of the High Court has reported before the expiration of the 3 months that the detention is necessary. And clause B is that any person who has been detained under law for providing for the preventive detention under clause A and B of clause 7. Then subclause 5 says that when the person is detained or arrested in pursuance with the order.
ये भी लगा
When a person is detained, when the person is detained or arrested in pursuance of the orders made under a law made by Parliament by the authority, then the authority who has made such order shall communicate with the person about the grounds on which the order has been made and shall give him the earliest opportunity of the representation against the office. Then Article Clause 7, Clause 6 says that nothing in the 2 Clause 5 तो बोल दिया ना, 6 बोल रही हूँ.
ठीक है चलो.
Yes sir. Then subclause 6 says that if the authority when the authority making the order shall not disclose, then nothing in subclause 5 shall require the authority who is making the authority to disclose the facts if they are against the public interest to disclose. Then Article 7 is the Parliament may by law can prescribe the circumstances if they are making, if the person is detained for more than 3 months without obtaining the opinion of the advisory board under clause A of subclause 4. And second one is the maximum period for the person who is detained for the law providing the preventive detention. Then C1 is for the procedure to be followed by the advisory board for an inquiry in accordance with the subclause A of clause 4. Then Article 23 is prohibition of traffic in human beings and forced labor. Traffic in human beings and beggar and other forms of forced labor are prohibited and the contravention of this provision shall be an offence which is punishable in accordance with law. Then subclause 2 state that nothing in this subclause 1 shall prevent the state from imposing the public services for the public purpose, but in making such service the state shall not discriminate against any person on the grounds of religion, race, caste, or sex, or place of birth. Then Article 24 is the prohibition of the employment of children in industries, that no child below the age of 14 years shall be employed in any industries or in mines or in any hazardous work. Then Article 25 is freedom of conscience and free profession, practice and propagation. Subclause 1 says that subject to the morality, public order and health and other provisions of the part 3 of this part, any person shall be entitled to the freedom of conscience and the right to freely confess, practice or propagate any religion. Then clause 2 says that nothing in the subclause 1 shall affect the operation of the existing law or prevent the state from making any law for regulating or restricting the economical, financial, political and secular activity which are related to the religious purpose. Then second clause says that B clause says for the promotion of the social welfare or reform or open throwing of the Hindu religious institutions of the public character of the class or sections of Hindus. Then Article 26 is freedom to manage the religious affairs. Then clause 1 says that subject to the public order, morality or health or other provisions of this constitution or the other provisions of this part, the denominational institution have the right to establish and administer the institutions for the religious and charitable purposes. Second one is to manage its own religious affairs. C1 is to own and acquire the immovable and movable property, and fourth one is to administer such property in accordance with law. Then Article 27 is freedom as to the payment of taxes for the promotion of any particular religion. That then in this article it's given that no one has the power to compel anyone for the taxes for the promotion or the maintenance of the promotion of any religious purpose or denominational institution. Then Article 28 is freedom as to the
Article 28 is freedom as to the attendance of religious instruction and religious worship in certain educational institution. That in clause 1 it's given that no one can, no religious instruction can be imparted in any educational institution which are wholly maintained out of this by the state. Then clause 2, subclause 2 says that nothing in clause 1 shall apply to the educational institution which are administered by state but they are established under the endowment or trust that the educational institution shall be imparted, that shall require that educational institution shall be imparted in such instruction. Then article subclause 3 says that nothing, article subclause 3 says that the person attending the religious institution which are recognized by the state and which are granted aid from the state of funds, out of the state funds, shall not be required to attend the educational institution or to attend any religious worship if the consent of that person, or if the person is minor, the consent of the guardian has been given. Then article 29 is protection of the rights of the minorities. Every section of the citizen residing in the territory of India who have a distinct language, culture or script shall have the right to preserve the same. Then article 2 says that no such person shall be denied to admission into any educational institution on the grounds of the religion, race, caste or sex. Then article 30 is rights of the minorities to establish and administer educational institution. All the minorities, whether based on religion or language, have the right to establish and maintain the educational institution of their own. Then 1A, in making any law, if there is a compulsory acquisition of property of an educational institution which are administered by the minority, then the state must be shall decide the form of accounts as may be determined by the law of for the acquisition of property. Then article 31 was repealed. Then article 31A was
31, 32 छोड़ दो, 33, 31 को छोड़ दो, 32 तो करना है, इम्पोर्टेंट है.
Article 32 is remedies for the enforcement of rights conferred by this part. The right to go to Supreme Court for the enforcement of the rights conferred by this part is guaranteed under this article. Then clause 2 said that the Supreme Court shall have the power to issue direction orders and writs like habeas corpus, mandamus, prohibition, certiorari or quo warranto for the enforcement of the rights conferred by this part. Then clause 3 says that without the prejudice of the power conferred on the Supreme Court, the Parliament may by law confer all the power or to any part of power to any court within the limits of the local jurisdiction to exercise such power which is exercisable by the Supreme Court under clause 2. Then clause 4 said nothing in this, the right guaranteed under this article shall not be suspended except the provision of given by the provision of this constitution. Then article 33, then article 32, then 33 to power of Parliament to modify the rights conferred. So part 4.
हाँ, 32 हो गया पूरा और
33 power of Parliament to modify rights conferred by this part while the application is in force.
33 छोड़ दो, 33, 34, 35 छोड़ दो.
Then part 4 is fundamental, the DPSP, Directive Principle of State Policy. Then article 36 is state. The state shall be the same definition as defined in the section 12 of part 3. Then section 37 is application of the policy to be contained in this part, that any provision contained in this part shall not be enforceable in any court, and the fundamentals and the principle are fundamental in the governance of the country, and it shall be the duty of the state to follow these principles while making any law. Then article 38 is state to secure a social order for the promotion of the welfare of the people. Clause 1 says that the state shall have the power, the state shall strive to promote for the welfare of the people by securing and protecting the as may effectively a social order in which justice, economic, political shall inform the institution of national life. Then subclause 2 says that the state shall strive to diminish the inequalities in income and shall endeavor to diminish the inequalities in status, opportunities or facilities facilities. Then Article 39 is certain principles to be followed by the policy state. Certain principles of the policy to be followed by the state. Then clause A says that citizens, both men and women, shall have the right of the adequate means of livelihood. B1 is the ownership and the control. The ownership and the control of the material resources of the community shall be distributed as best as to serve the common good. C1 is the operation of the economic subject shall not result in the concentration of wealth and means of production to the common detriment. Then B is both that there shall be equal pay for equal work for both men and women. Then clause E is that both the workers of both men and the strength and the health and the strength of the workers, men and women, and the tender age of the children are not exploited, and the citizens are not forced by the economical necessity.
Children are not abused.
And they are not abused, and the citizen shall not be, and citizen shall not be forced by the economical necessity to enter the vocations unsuited to their age and strength. Then F is the children are provided with the facilities and opportunities in the healthy manner and in the condition of freedom and dignity, and children and youth are protected against exploitation and the moral and material abandonment. Then 40 is equal justice and free legal aid. The state shall endeavor to secure to all its citizens to promote justice on the basis of equal opportunities, and shall provide with free legal aid by the suitable legislature or schemes or in any other work for ensuring opportunities that are not denied by any citizens by the reason of economic and other disabilities. Then Article 41 is right to work, to education and to public assistance in certain cases. The state shall in the capacity of in its economic capacity in development shall make provisions for securing the right to work, to education and to public assistance in cases of unemployment, old age, sickness or any disablement or any other unwanted undeserved want. Then then Article 42 is organization of village panchayats. The state shall endeavor to organize the village panchayats and to endow them with such powers and authority to enable them as a function as a unit of the self-government. Then Article 43 is living wages of the workers, that the state shall endeavor to secure to all its workers agriculture, industrial, a work or living wage and a condition that securing a decent standard of life and full enjoyment of leisure, and the cultural and social opportunities and the cottage industries and the cottage industry of an individual or cooperative basis in rural areas. Then Article 43A is participation of workers in the management of industry. 43B is cooperative societies. And 44 is uniform civil code. The state shall endeavor to secure to all its citizens a uniform civil code within the territory of India. Then Article 45 is provision for the early childhood care and the early childhood care and education for the children below the age of 16 years. Then Article 47 is the protection of the scheduled, protection for the educational and economical interest, protection for the educational and economical interest of the scheduled tribes, scheduled caste and other weaker section of the society. Then 47 is the duty of the state to raise the level of nutrition and the standard of living and to improve the public health. It shall be the state shall endeavor to raise the level of the nutrition and raise the nutrition of the level of the nutrition and the standard of living and the improvement of public health, and should prohibit the prohibition of intoxicating drinks and drugs which are injurious to health, except the medicinal purposes. Then Article 48 is organization of animal husbandry for agriculture and animal husbandry, that the state shall endeavor to organize the agriculture and animal husbandry for the preservation and improvement of the breeds and the prohibition of slaughter of cows and calves. And then 48A is protection of agriculture, for the protection and improvement of the environment and the safeguarding of wildlife and forests. Then Article 49 is the protection of monuments and places and objects of national importance, and 50 is separation of judiciary from executive. 51 is in promotion of international law and international security and peace, that the states shall endeavor to promote international security and peace, or to promote the international peace and security, or to settle the, or to encourage the settlements or the settlements of the international disputes by arbitration.
Very nice. पूरा हो गया?
51 duties, fundamental duties भी अच्छी है, 4A, हाँ, fundamental duties भी अच्छी है. It shall be the duty of every citizen to abide by the constitution and to respect its ideals and institutions of the nation and national flag and national anthem. Then clause B is to cherish and follow and to cherish the noble ideas for which has inspired our national struggle for freedom. Then clause C is to protect, to uphold and protect the sovereignty, unity and integrity of nation. Then fourth one is to defend the country and to render any national services whatever is needed to do so. Then E1 is to promote the harmony and the spirit of brotherhood among all the people of India transiting linguistic, regional or sectional diversity, or to renounce the practices which are derogatory to the dignity of women. Then F is to protect and preserve the rich heritage of the composite culture. Then G is to protect the and improve the environment, natural environment, including the forest, lakes, rivers and forest, and to have the compassion for living creatures. Then G is to develop the scientific temper or the spirit of humanism and the spirit of inquiry and reform. Then I1 is the to safeguard the property, to public property and to observe the violence. Then I1, then J is J.
To strive towards the excellence.
To strive for the excellence in all the spheres of individuals and all the collective activity, to strive to so that the nation can rise up to the higher levels of endeavor and achievements. And K is who is the parent or guardian, to provide the education for the to his child, or as the case may be, as the ward is between the age of 6 to 14 years, to his